the fun part. We have an incredible couple of experts sharing with us this morning, and to introduce them, I'd like to hand it over to our VP Construction Risk, Chad Watts.
Good morning. Thank you, Sarah. I am thrilled to introduce to you our speakers. We'll start with Dominic Anton. He is a financial advisor at Twin Rivers Wealth Management, where he manages retirement plans for individuals and businesses throughout Sacramento and the greater Northern California area. He holds the Certified Financial Planner, Accredited Portfolio Management Advisor, and Behavioral Financial Advisor designations. With over a decade in financial services, Dominic's expertise spans group retirement and pension plans, as well as helping business owners and executives with investment management, estate planning, and tax planning. He's built his career on a simple philosophy, helping clients gain real financial clarity so they can execute with purpose. Thanks for joining us, Dominic. And our next presenter, Josh Itzo. Josh is the founder and CEO of Perceptive and creator of Fiduciary U. Fiduciary U is the retirement industry's leading fiduciary planning platform. Josh is an Amazon best-selling author of the Fiduciary Formula, 6 Essential Elements to Create the Perfect Corporate Retirement Plan. He's a podcast host, a CFP, a former Green Spring Advisor co-founder who scaled its retirement practice to $4.5 billion and was named the 2018 Plan Sponsor Retirement Plan Advisor of the Year. He specializes in fiduciary governance and due diligence technology, consulting, and training for retirement plan advisors and employers. Let's go, gentlemen. I'm going to go ahead and hand it off now to Josh. The floor is yours.
Thank you, Chad. Appreciate it. I think, as Sarah said, if you have questions, feel free to submit them as we go along. There's a decent chance they'll get answered during the presentation. If not, we'll cover those at the end. So today's presentation, I'd like to describe it. I have 2 kids in college. This is going to be like a kind of a level 100 course. I want to really kind of hit the high points for you. I want to make this as practical and actionable as possible, and also dispel some of the, I would say, kind of myths that exist out in the marketplace. We could certainly go to 200 or 300 level courses, but I think unless you really want to get deep in the weeds, I think what will be better today is if we keep this at a high level and make it actionable. So first and foremost, here's what we're going to cover. We're going to walk through just the basics of what it means to be a fiduciary. It's a very important role and responsibility. A lot of times it gets kind of overlooked. And so if you are a fiduciary, it's important to understand what that looks like and whether you are or whether you aren't, and what the responsibilities and potential liabilities are associated with that. We'll cover the 5 kind of core principles or legal duties under the Employee Retirement Income Security Act. That's called ERISA. And so that's principles that are kind of enforced on every fiduciary. And that's one of the important things that we're going to talk about, is that it's a framework that actually has principles, and then what has I think been built or created within the industry to fulfill those principles and those practices are really best practices. And we'll talk about some of those, like investment oversight, how to manage plan costs. We'll also talk a little bit about operational failures and corrections and what happens when plans break down. That's actually the biggest risk for most companies. It's not necessarily litigation, which there is a lot of litigation, especially in the large company space. But the bigger risk for most companies, especially small businesses, is operational failures that can occur with your plan. And these are actually very common, but when they happen, methods have to be followed in order to correct them. And it can be very simple. It can also get to be really complex and burdensome and costly. And we'll talk a little bit about that. We'll talk a little bit about the importance of participant education and helping your employees really understand and hopefully appreciate the plan that you offer. And then what are the next steps and the actions that you can actually take, on Friday morning to really fulfill this important responsibility a little bit better. So first and foremost is understanding whether or not you are a fiduciary as it relates to your company. And I think one of the most important things to understand is that fiduciary status isn't determined by necessarily your title or your role within the organization. It's determined by what you do as it relates to the retirement plan. And so you're a fiduciary if you do a number of different things. And so here's some examples of what that looks like. If you as the company either make or approve investment decisions about the retirement plan, and what that means, kind of like conditions on the field. If you individually or as part of like a benefits committee or a retirement plan committee or an investment committee select what investments are going to be made available to your employees to invest their accounts with, that's a fiduciary function. If you have the decision-making authority, and under ERISA, they call it discretion. You can just substitute decision-making authority for discretion. If you have that authority to select and hire and monitor different service providers. So whether that means your advisor, which is the role that Dominic plays in the kind of fiduciary ecosystem. If that's a record keeper like a Fidelity or a Vanguard or an Empower or a Principal Financial or big financial institutions that provide record keeping services, that's a fiduciary function. If you have a third party administrator or what's known as a TPA that helps with the administration and the operation of your plan, that is a fiduciary function. If you handle plan assets or transactions operationally, and so getting money into the plan, making sure that it's invested appropriately, that can be a fiduciary function. If you deal with any of the administration, how the plan's operated, the implementation of whatever the plan features are that are specified in your plan document. Every plan has a document, and that document governs both the rules and regulations, but also how the plan needs to be operated. And when we talk a little bit later about operational failures, what is very common for companies of all size is that you can, usually through what I would call an act of omission, not an act of commission. It's not intentionally, but a lot of times what happens is, for whatever reason, perhaps your internal business processes and how the plan is operated in the real world doesn't match what the plan document says. But when that happens, that's called a plan failure, and that needs to get corrected. And we'll talk a little bit about that. But the implementation, it's not choosing what features are in your plan isn't a fiduciary function. That's called, under ERISA, it's called a settler function. That is not, settler functions are not fiduciary in nature. So making decisions about, for instance, are we going to include automatic enrollment within our plan where employees come into the plan and instead of having to elect to join the plan, they're just automatically enrolled and they have the opportunity to opt out if they want, but they're automatically enrolled unless they opt out. The decision to offer automatic enrollment is not a fiduciary function. That's what's called a settler function. But once you've made that decision and now you have to implement that process, it becomes fiduciary in nature. So administering plan features and designing the plan and then really the implementation of it is fiduciary in nature. And then if you sit on a decision-making body like a retirement plan committee or an investment committee or a benefits committee, a lot of times what is a best practice and what most companies, especially as you get larger, but I would argue even the smallest plans should have some type of retirement committee that has multiple leaders within the industry across different functions. So maybe that's accounting, maybe that's finance, maybe that's HR, maybe that's executive leadership. The best plans are run with a committee, not a committee that's too big. You don't want 15, 20 people on your committee because nothing will ever get decided. But generally, a committee of 3 to 5, maybe 7 on the high end that are tasked by the board of directors to collectively make the decisions about the plan. That is a best practice. If you sit on that committee for your company, that is a fiduciary function. Some of the common misperceptions that are out there, a lot of times people don't understand that it's determined by what they do, not what their title says. So a lot of times people say, well, I'm not named as a fiduciary, like that's not in my job title. Title doesn't matter, function. If you perform what are deemed to be fiduciary functions, you're a fiduciary by nature. You can delegate certain functions out to third parties, but you always retain an oversight responsibility as a fiduciary. And so that's the good way to think about it is you can delegate primary fiduciary responsibility to third parties, but that doesn't allow you just to flip them the keys and walk away. Even if you delegate, you will fall back to kind of a secondary oversight responsibility. And so unless you shut the plan down and aren't involved at all with it, doesn't necessarily mean that you don't have any responsibility. A lot of times people think, for instance, their advisor handles everything. As I mentioned, oversight stays with you, even if you've delegated certain things. The reason you want to have multiple service providers is because there are different functions as it relates to running a retirement plan. As I mentioned earlier, you have to handle you need a record keeper. You need someone to do the administration of the plan. Sometimes that's done by a single entity. So maybe a company like Fidelity, a record keeper does both the record keeping and administration. In other cases, those responsibilities may be segregated. You may have a record keeper and then a third-party administrator involved. You have an advisor. If your plan is generally speaking over 100 employees, you have to have an audit done every year that's done by a qualified CPA firm that does retirement plan audits. The key from your perspective, I think, as a company or what's called a plan sponsor, is you want to identify, like, what do we need to do to run this plan optimally? What functions do we need? What services do we need? And then go out and kind of pick your team in a prudent way and in a comprehensive way and get the right people on the team. And then everybody needs to work together. But ultimately, you can think of those as you're the head coach as the organization, and hopefully you've got multiple star players that are actually kind of on the field making the plays, but your job is still always to come up with strategy and then make sure the players are doing what they're supposed to. And then lastly, one of the common misperceptions is, hey, I just get the paperwork and it's sent to me and I sign it. But signing equals discretionary action. And again, that word discretion, you can substitute decision making. So if you're responsible and your signature goes on the different documents, very high likelihood that you are a fiduciary, whether you realize it or not. One of the things that's important is that under ERISA, that fiduciaries can be personally liable for the decisions that they make and the things that they do. And there's a lot of fear mongering in the industry around liability. I think a better way, to describe it is, you have responsibilities. Liability is a possibility, but you don't cross over into liability until you do things wrong. And mostly what happens is it's not when whether it's fiduciary breaches or operational failure, it's not because someone's intentionally trying to do that. It's usually an act of omission. They either didn't know. It's not a kind of didn't care and they do it, intentionally. It's usually unintentional. The way I like to describe it is, you have personal responsibility as a licensed driver to drive your car. And hopefully when you get in your car, you're putting on your seatbelt and you're driving within the speed limit and, you're driving defensively. That is how you are a good driver. You've got responsibility when you get behind the wheel. You've got a machine that you're in control of that can do a lot of damage. And so it's very important to be responsible when you drive. This hits home for me because I have 3 licensed drivers. 3 of my 4 kids drive. And so, we're very adamant about them being, responsible when they're behind the wheel. They don't cross over into liability until they become irresponsible. And so, you don't have, when you're behind the wheel, you have potential liability, but it doesn't become real until you're texting on your phone and you're not paying attention and you hit somebody from behind. Well, now you've got liability. And I think the same thing is important when you think about being a fiduciary. You have got responsibilities, and there are ways that you can be really diligent in those responsibilities. Personal liability is possible, but it is improbable in most cases for most companies. As I mentioned, there is litigation. It is timely, it is costly, it is painful. But generally speaking, that liability and that litigation risk is usually really upmarket. As Chad mentioned, I host a podcast that's pretty popular in the retirement industry called the Fiduciary U podcast. And I get to have a lot of really impressive kind of experts on that podcast. And a couple of years ago, I had a gentleman who, back around 2004, 2005, 2006, he was the plaintiff's attorney who pioneered ERISA litigation. ERISA litigation came into play about 20 years ago, and he was the guy who created kind of the playbook, and he sued a lot of big companies. I think his biggest one, he sued Lockheed Martin on behalf of their retirement plan participants, and ultimately Lockheed Martin settled for $63 million. In damages. Now, it's important to realize that Lockheed Martin had a $10 billion retirement plan. And so I asked him, and his name was Jerry, I said, Jerry, like realistically, what size plans are you targeting to go after? And he proceeded to describe the fact that this litigation is very expensive and it is very time consuming. 5-10 years. I think one of the first cases, actually, it took like 13 or 14 years for it finally to be wrapped up because it was constantly under appeal and relitigated. And he said very directly, he said, look, we work on contingency, so we take a percentage of whatever the settlement is. And he said, we have to be very selective about the cases that we take on because any one, if we get it wrong, could put us out of business. So he said, realistically, in terms of litigation, he's like, we're looking at plans that kind of the floor is about $200 million. And so that was a couple of years ago. There are cases where, smaller companies and plans get sued, but the reality is the likelihood is if you're, call it below $150 million in plan assets, you're probably not living in the neighborhood where litigation, unless there's fraud involved, is really a probability. It's very improbable. It's much more probable as a small company that you're going to have operational failures, which we'll talk about. So here are the 5 kind of core principles or duties under ERISA. And I want to say that these are principles. They are kind of broad. They're not specific. And that's important to know. So the 5 are this: a duty of loyalty. That means that your job as a fiduciary is to work in the best interest of your plan participants. When you're a fiduciary, you can't put your personal hat on. You have to take your personal hat off, or the hat representing the company, and you need to put on the hat of what's in the best interest of participants. That is kind of the cornerstone fiduciary principle. Your job is really to serve others, not yourself, not your company. Sorry. The second is what's called the duty of prudence. Prudence is just a better way to say that is wisdom. You have to make decisions with care and with diligence. And the courts and the Department of Labor, when they look at fiduciary performance, what they're really looking at is, do you have a diligent process in place? A lot of people will tell you that outcomes don't matter. It's all about the process. I don't think that's an accurate read. Outcomes always matter, but what you can control is you can control the process that you follow for how you look at the investments, how you manage the costs, which vendors that you hire to work with your plan. And it's not a set it and forget it type of thing. You don't just do it once and then not do it again. It is an ongoing process. Things change without out in the market or with rules and regulations, how the investments in your plan perform, what the cost structures are, the service that you get from your vendors or the services that they provide, that is very dynamic and fluid, and it changes over time. And so you have to have, once you make decisions, you have to then transition into a process of consistently making sure that you don't fall asleep at the wheel. And that's what it means to be prudent. We're going to make wise decisions. We're going to implement a comprehensive due diligence process, get clarity around all the information that we need, understand that information in the appropriate context, and then make a decision based on assumptions that we are going to, that the assumption that they're going to lead to good outcomes. And then you have to just monitor and make sure that things are playing out the way you intended. It's a lot like, think about running your plan the way you run your business. You probably have a strategic plan, I would hope. And, it's probably the executive leadership that get together annually and take a look at that plan and figure out this is where we're going and what we want to try to accomplish and achieve. And you probably have certain metrics or key performance indicators that are going to help you understand, are we on track? Are we off track? And then you probably have actions that you and the rest of your team are going to implement over time that hopefully will lead to the outcomes that you want. It's the same type of thing with your plan. The committee, the decision makers, you set the strategy. It's important to come up with those key performance indicators when you look at the various aspects of the plan and be able to track those. And sometimes you're going to deviate. Hopefully you're going to stay on track. Sometimes certain KPIs might deviate. Well, it's important to know that and find that quickly and then take action to get back on course. And that's what it means to be prudent. The third is the duty to diversify. So to diversify the investments in the plan so as to avoid the risk of large losses. That's the easiest thing to do in this day and age. Generally speaking, the Department of Labor has specified that if you have 3 different types of investments, let's say a cash investment, a stock investment, a bond investment that you make available to your participants in the plan, that fulfills the diversification requirement. The reality in this day and age, ERISA actually was implemented in 1974. The first, and it's back when there were pension plans. The first 401k plan didn't come into existence until 1979. And so when ERISA actually became law, there wasn't even a concept of having a retirement plan that your employees would have some measure of control over their own retirement balances. It was all managed by the company with pension plans. So diversification is probably the easiest fiduciary duty to fulfill. The fourth is to follow the plan documents. And again, every plan has documents. You can have a plan document, an adoption agreement. There's different amendments over time. Things like an investment policy statement, which is a best practice, not required by ERISA, but is a best practice to evaluate and monitor investments, as an example. Those become instruments or documents of the plan. And once those are in place, you have a responsibility to operate the plan and align with those documents and whatever they say. They kind of set the rules up, and your job is to operate the plan according to those documents. And if you deviate, that can lead to an operational failure, or even a breach of fiduciary responsibility, and it needs to be rectified. And then lastly, costs matter. Most of the litigation over the last 20 years has been primarily focused on excessive fees. And the gentleman that I mentioned earlier, that's where he pioneered ERISA litigation. It was going after companies and really focusing on the fact that they hadn't been prudent in how they'd managed the cost structure of their plan. And that was really kind of the attack vector or the attack surface that he and his firm initially went after and was really successful with. Because the costs in a plan compound over time, usually as the assets in the plan grow. And so having a really good process around how you evaluate the overall cost structure, the revenue flow, and you monitor that ongoing is really, really important. So let's shift into some of the best practices. So there's much more to a retirement plan and a successful retirement plan than just the investments, but that's the big one that people kind of focus on and they think about. And so investment oversight, it's really important to have a actionable process that you can follow on a regular basis. As a fiduciary to the plan, you're not in this every day. You're not an industry expert that lives and breathes and deals with this stuff every day. You actually don't need to be an investment expert. What you need is to exercise good judgment, hire experts, and then make sure that whoever you've hired is helping you implement a consistent and documented process. So that's the number one thing. And if you only take one thing away from today's presentation, I would say it's this: document, document, document. The Department of Labor's posture is, if you didn't document it, it didn't get done. And so a simple way to do that is, as an example, meeting minutes. Every time you meet to deal with the plan, have somebody take minutes. Who was there? What was discussed? What was analyzed? What information you looked at? What decisions were made and why those decisions were made. The companies that have been successful in litigation, not every company loses ERISA litigation. And the ones who typically are successful in defending themselves, it's because they have historical documentation that they could use to counter the arguments that plaintiffs make. I had mentioned it earlier, but one of the best practices is what's called an investment policy statement. And there is more to an investment policy statement than just downloading a template off the internet and throwing it in your files. That's kind of like, somebody who has a large estate downloading a will and off the internet and filling it out. Probably not going to be sufficient. I think if you talk to any ERISA attorney in the country, they would tell you it's a good idea to have an investment policy statement, but if you have it, you need to make sure that it's constructed appropriately and you follow it. Because if you don't follow it, you're basically leaving a breadcrumb trail to a plaintiff's attorney to attack you. And so ERISA does not mention an investment policy statement. It is not required under the law, but it is one of the best practices that as an industry, the retirement industry has come up with in the investment industry to fulfill that duty of prudence. And so what an investment policy statement does is that it defines the criteria for how you're going to select, monitor, and remove the investments that are in your plan. It's kind of like your operating manual. It's very important to make sure that whatever you specify in that investment policy statement, and this is why boilerplate documents can get you into trouble. If you're going to specify criteria so that you can objectively evaluate whatever investments you choose to select within your plan, you need to have a process to make sure that you monitor whatever that criteria is. So that's an important element. The other thing is, be very careful about the language that you have in your investment policy statement. You want the investment policy statement to be a framework by which you operate, but not a mandate that really boxes you boxes you in. And so the language is really important. Things like, just as an example, the word must versus may. So, you want your investment policy statement to be as specific as necessary to give you room to operate, but not so specific that it forces you to do things that may not be prudent. And so even like the example of a fund that fails our criteria for 4 quarters in a row must be replaced. Well, investments are going to go up and down. Sometimes they're going to behave the way you want them to. Sometimes they aren't. If it says you must replace them after 4 quarters of misbehavior, you have to replace them. A better way to write that is, a fund that fails performance criteria for 4 quarters may be replaced. That gives you room to operate. So be very careful with your language. Also, you want to use a combination of what I would say quantitative criteria and also qualitative criteria, but it needs to be objective. So just examples, you want to look at expense ratios, the costs associated with the funds. You probably want to look at performance against benchmarks over time. Things like manager tenure. So what happens, like any company, you may have a fund manager who's performed really well and that fund manager retires or he goes to another company. Well, that should trigger some evaluation because the person who was responsible for making decisions that led to that good performance is no longer there. So that's something that you want to be aware of and you want to investigate more fully. There are a lot of different quantitative criteria that you can use, but also there's the qualitative aspect, and you always want to give, you want to give yourself the freedom to look at qualitative factors as well. You should review this information regularly. Now, industry standard is on a quarterly basis. Most large companies, they look at this stuff every quarter. If you're smaller, I would say you need to have a regular cadence. If you can do it quarterly, that's great. But I would tell you, you should be reviewing the plan, not just the investments, but the investments, the fees, the operations, your vendor relationships. You should be evaluating that no less than annually. And again, depending upon, size, you may be a small business, you just don't have the resources, but you shouldn't go 2-3 years. Think of this as like at a minimum, you should do an annual checkup and go see your doctor and get a physical every year. It's the same type of thing. You may be really committed to your overall health, and so you get blood work done, on a more regular basis, and then you do your annual, physical. If you want to do that, absolutely. But no, you shouldn't go 2, 3, 4, 5 years without going to the doctor. You should do it at least annually. So hopefully if you catch anything, you've got time to take action. And that's the last piece is when it comes to your investments, sometimes they're just not going to pan out the way you thought they were. You selected an investment, made it available in the plan to your employees for whatever reason. You had a good process, but the outcome, which is out of your control, it just didn't perform the way you thought it would. You can't just turn a blind eye. You need to take action. So if there's a fund that consistently underperforms or violates your IPS criteria, you just can't let that go on forever. You have to take problems. A lot of times issues arise when persistent problems or persistent issues actually turn into long-term problems because you just continue to kind of kick the can down the road. I mentioned plan fees. So when it comes to plan fees, this is a big hot button. ERISA doesn't require you to use the lowest cost vendors or investments. It requires that fees are reasonable for the value received. So number one, you got to know what you're paying. There's a lot of direct costs in the retirement industry, but there's also indirect costs, often known as like revenue sharing, which can be third-party payments behind the scenes that you don't really see, or they can be kind of kickbacks, if you will. So the first thing you want to do is you want to get a complete picture of the overall revenue flow. So who's getting paid? How much are they getting paid in dollars? What does that represent as a participant of assets? What's the structure? Is it an asset-based fee that grows as your assets grow? Is it a fixed fee that kind of stays the same and isn't dependent upon, asset growth or an increase in the number of your participants? Is it a participant per participant fee? If you have 500 employees now, or let's say 100 employees now, and you're paying X dollars per participant, $100 per participant. Well, that's $10,000 in total fees. If you acquire a competitor and now you go from 100 employees to 200 employees and you're paying $100 per participant, well, now you're paying $20,000. And so you want to know that structure. The most common fees related to a retirement plan are your record keeping fees, the expense ratios, that's the cost of the funds, advisor or consulting fees, and then administrative or third-party TPA fees. Sometimes you have record keepers that are what are called bundled. So the record keeper, one company does both the record keeping and they do the administration. That's going to be one organization that's being paid to do both services. In other cases, those may be separate functions. So you may have one company that's the record keeper that gets paid, X, and the other, company is a third-party administrator, and for their services, they get paid Y. And the overall cost of record keeping and administration is X plus Y. So understanding who gets paid how much, what's the structure, really, really important. And then you want to follow, I have here just kind of a 3-step fee review. And it starts with inventorying all your costs, what you see and what you don't see. Sometimes those fees are buried. You want to periodically benchmark what your fees are against the market. And there's an advisor can help you, do this with a lot of the fees that are within the plan. There are databases that are out there. I would say database or report benchmarking is kind of like, it's like fiduciary hygiene. It's like brushing your teeth and putting on deodorant every morning. You want to just do that. That's just good fiduciary hygiene. Periodically, and what the Department of Labor has said is every 3 to no more than 5 years, you should go out and do something more formal, like a request for a proposal or an RFP, where you actually go out to the market and you gather proposals and bids. That's the most accurate way to benchmark your plan. You don't have to do that every year, but you should be doing that every 3 to 5 years. And then the last step is, whatever that project or that process looks like, document it. Record what you found, how you did comparisons, what your conclusion was. That's your best defense. And as I said, fee litigation is the major hot button and has remained the major hot button for 20 plus years. Okay, we're wrapping up here, but the real risk, as I mentioned before, if you're a smaller company, the likelihood of ERISA litigation being sued is not very high because of the time, the cost, the expense. There are no punitive damages under ERISA, so there's no unlimited or uncapped upside. And if a plaintiff's attorney is going to have to spend 3, 4, 5, 10 years litigating this, the plan's got to be a sufficient size that they're going to be able to, be profitable and not go out of business. The bigger risk as a small company is operational failures. While litigation is rare for small companies, operational errors are very common. And depending upon the extent of the failure and how long it's existed, it can get really expensive to fix. And so I'm not going to get deep into these, but I want to give you just some high level ones that are examples. A big hot button for getting audited by the Department of Labor or the IRS is late deferral deposits. So when money is withheld from employee paychecks and then deposited into the plan. If they're not deposited as soon as reasonably possible, you can pay excise taxes and have to calculate lost earnings on that money if it doesn't make it into the plan in time. And so it's very much tied to your payroll system. There's a safe harbor for small plans. It's usually within 7 business days. And if it's late, it's a prohibited transaction. If it's outside that. That being said, the Department of Labor defines as soon as reasonably possible. You might have a 7-day safe harbor, but if you consistently get the money into the plan in 3 days, the Department of Labor historically has said, well, if you have shown you can do it in 3 days, like that's the time frame you need to get it in. The big thing here is if you have late deposits, it gets filed on your Form 5500 every year. And that is like the #1 trigger that the IRS looks at every year in determining like plans that they're going to audit. So making sure that your procedures internally, especially around payroll and funding, are really tight and you're on top of that to avoid late deferral deposits. It can lead to lots of other areas. Missed RMDs, eligibility. Your plan document says that once somebody has been at the company for 3 months, they become eligible. Well, if you aren't tracking that well and it doesn't get until 6 months that, you finally get that person in or give them the opportunity to join the plan, well, you miss their eligibility date by 3 months. You have to put corrective contributions in order to and calculate gains and losses, for that 3 months that they missed. Not following the plan document, loan and hardship with failures. If your plan allows loans or hardships, there's a lot you have to do to monitor and make sure that those things are being implemented correctly. And then failed non-discrimination tests. There's a couple of tests that get run every year. Things like the average deferral percentage test, the average contribution percentage test, the top heavy test. There are tests that have to be run to make sure that your highly compensated employees aren't getting a greater advantage than your non-highly compensated employees. And usually it's going to be your record keeper or your third-party administrator that's running all the math for you. When you fail these tests, generally you need to refund money to your highly compensated employees, or you need to make contributions to your non-highly compensated employees to make the math work. There are ways around certain of these things, like a safe harbor plan that exempts you from these tests. What most companies don't realize is you could be a safe harbor plan, and that deals with like a match. But if you also offer a profit sharing, you still have to go through testing. And so just making sure you're on top of these things. When you have operational failures, they are very common. When you do, there are three ways you can correct them. The IRS has a couple of different programs. The first one is just self-correction. It's free to use. These are minor or insignificant areas that are corrected within a short period of time. If you find the error, you don't have to file anything with the IRS. You don't have to pay fees in order to do that. You can correct it. A lot of errors are small. You just want to make sure you find them quickly, you resolve them, and then you make any internal changes to your processes that you need to. This is kind of like best case scenario when operational failures occur. They're small, they're minor, they're insignificant, and you can just deal with them. Sometimes, though, they might be more significant, or they might have gone outside. There was an error that you didn't catch, and it goes for an extended period of time. The second type of correction program is called the VCP, or the Voluntary Correction Program. And you can see that occurs when you're outside the appropriate timeframes, or the issue is bigger, or it's more systemic. And this is more involved. You actually have to submit an application to the IRS. There are fees associated with doing that. You have to get approval and get the IRS to sign off on those correction methods. But what you're trying to do is protect the plan from disqualification. And then lastly is what's called audit cap. This is like the nuclear worst case scenario. You get audited, and instead of you finding your own errors, or through with the help of your third-party administrator, your record keeper, your advisor, the IRS or the DOL audits your plan and they find errors. It gets really expensive, and it is very time consuming. Hopefully what you're doing is you're finding your own errors and correcting them with the first two methods, and you don't even get to the third one. But I can tell you that's a painful, costly thing to happen. It does happen. But my biggest advice to you is don't go this alone. When you find errors, in some cases, if they're significant enough, like, you should bring in an outside expert. You might want to bring in your CPA. You may want to hire an ERISA attorney. An ounce of prevention is worth a pound of cure. And so it might cost you a little bit of money, but it's a very good, you're going to want to do this. Don't do it on your own. Quick little anecdote. I had a client one time. This was a larger company. It was a couple of thousand people. They had like $100 million in their plan. And it turns out that they got audited, and there was an operational error that was happening within their plan that actually was done by one of their people who dealt with the plan operationally. And she was an awesome employee, and she'd been doing it for like 10 years. And she had been trained by her predecessor on the way to do it. And so she just continued to do what she had been trained to do. Well, it goes 10 years. She thought she was doing it correctly. Nobody on the committee, nobody knew that this is actually what was happening. The plan got audited by the IRS. During the audit, the IRS auditor found this issue and started to dig, and came to the CFO and started to ask the CFO questions. And he was in a panic, and he started to just like try to answer the questions because he was worried about getting in trouble. And the questions got harder and harder and more direct and more pointed, and the scope started to expand. The auditor was just looking for whatever she could. And so he called me, and I said, stop talking to the auditor. I was like, we need to bring in an ERISA attorney. And he's like, yeah, but that's going to cost money. And I'm like, this is going to cost money no matter what. Trust me, we need an ERISA attorney. So we brought in an ERISA attorney, and it was the best thing that we could have done. This wound up being well into the six figures to fix that they had to do, but the IRS had proposed something far higher than that. And bringing in the ERISA attorney, he was able to stand between the CFO and the auditor and start pushing back and really start to firewall things off. And so the auditor then started to ask the ERISA attorney questions, and he's like, yeah, we're not going to do that, and here are the reasons why, and you can't ask for that. And he wound up saving far more than they paid him because he was able to negotiate the penalties down. So that's just kind of key takeaway, something to think about. There are operational support that's available. Technology, when it's designed the right way and it's operated effectively, can be your friend, especially a lot of issues happen payroll wise. So payroll integrations and making sure those are accurate are good. Some record keepers and TPAs can really take on fiduciary responsibility as what's called a 316 fiduciary. They can help alleviate some of the administrative day-to-day responsibilities. You can actually delegate the fiduciary responsibilities to them. What I would tell you is it's really important that you understand the scope of the service agreement, because not all 316 services are the same. And so you really want to make sure if you hire this and outsource or delegate anything, that you actually know what your responsibilities are and what the third party's responsibility are. But in some cases, it can be really valuable. And then on the investment side, having a fiduciary advisor like Dominic can help. And there are two roles within ERISA as a fiduciary advisor. The first is what's called a 321. That's just a section of ERISA where they give you fiduciary advice that's in your best interest, but ultimately you make the final decisions about the investments. So you own the decision-making process. The other way it can be done is what's called a 338 investment manager. It's a different role under ERISA where you can actually delegate or outsource to your advisor, and they take over primary responsibility for selecting and monitoring the investments, and you fall back into an oversight role. But by delegating that out, you can delegate out your primary fiduciary responsibility. So as we're wrapping up, just really quickly, and I think Dominic's going to cover this. The other things we've talked about is actually kind of like your experience as the business and as the plan sponsor. Your employees' experience is also really important. So, employee education, potentially employee advice are really valuable. People need help with these plans. There's something called ERISA 404C that if you fulfill that, it gives you some fiduciary kind of safe harbor for once your employees actually start to make their own investment decisions, which is really valuable. And then having an engaging employee education program. And like I said, Dominic's going to talk about that. This is a benefit you offer your employees. You want to make sure that they understand it and hopefully that they appreciate it. And it can be a differentiator for you as a business. Providing someone to talk to and get guidance and even potentially advice and understanding is something that really helps employee morale. It shows that it reduces long-term financial stress. It can also help some of your older employees as they're approaching, their retirement date, be more prepared. And it's really about designing the plan to help people retire with dignity and not despair. And so as I wrap up, I'll leave you with this. As I mentioned before, if it's not written down, it didn't happen. So the last thing you can do, you have to retain documentation, a fiduciary file. It's something like Dominic can help you with, but you want to keep records and you want to keep them for at least 6 years, but indefinitely is probably a best practice. Things like your investment policy statement, your investment reviews, meeting minutes, any fee benchmarking analysis or documentation you have. When you go through a request for information or request for proposal process and how you selected your vendors, making sure that you've got documentation that all the required notices were delivered on time, what your non-discrimination test results will look like, so on and so forth. The most important thing is just when you meet to talk about the plan, take minutes. It's simple. It's not always easy, but just have somebody be chief scribe and take minutes and document everything you do. So with that, I'm going to hand it over to Dominic and let him take the rest of the presentation, and then we'll get to questions.
Excellent. Well, thank you, Josh. No, and if you're listening to this webinar and you feel a little bit overwhelmed, there are a lot of different aspects that come to covering 401k plans, retirement plans, and thanks for the incredible information again, Josh. Where the rubber can really hit the road is, through an assessment, a structured assessment process. And so one of the resources you're going to receive after today's webinar is a link to a questionnaire. This questionnaire only takes 5-10 minutes to complete. And there's, it looks at 6 core areas of your retirement plan. And what this does is it really helps you gauge the overall fiduciary health, right? So once that report is generated, we can see, okay, are we scoring, out of 10 or 15, and we have a whole bunch of areas to cover, or are we doing a little bit better than we potentially expect? Josh, if you go to the next slide, please. So it'll help score the fiduciary health of your plan from a big picture perspective, but it also, show you on a more granular perspective, certain areas. So, have you evaluated the overall plan design? Have you benchmarked your plan out recently? And do you have a competitive fee structure, and can you document that? Do you offer good participant support and communication and education for your staff members? One of the things I've seen is, participant support and education is an absolute game changer. That is where the rubber hits the road. You can offer the best retirement plan in the world, but if nobody understands it and nobody, participates in it, it doesn't really matter. Right. And so if we're going through all this work to help support the organization, support your employees, definitely make sure that we have a good communication plan in place. The other key areas are looking at fiduciary governance. So, your documentation process, your meeting minutes, looking at your investment process, and lastly, provider management. Can you go to the next page, Josh? So one of the beautiful things about this is not only does it help score the health of your plan, but it focuses on what you're doing well, and also identifies the key areas of opportunity and where you can improve in specific areas. So this is not only a very helpful document to gauge your plan from a high level perspective, but it helps to create the roadmap and start that process of improving the overall operations of the plan. So again, so that'll be sent out as a follow-up resource for all those who are attending. So now we're going to open the floor for questions. Josh, I do have a couple of questions for us here.
Okay, fire away.
So the first question is, what are the general trends you're seeing in the industry that plan sponsors should be aware of?
Yeah, so I think that's actually a great question. So there's a lot of evolution that is out in the marketplace right now. I think generally speaking, what we're seeing is there's always a component, I think, from a cost standpoint. I would say in general, costs are getting more competitive and vendors are offering more services. And so kind of gone are the days, of where, you hired kind of a vendor that didn't have a lot of experience. I think one of the big trends is towards specialization. There's a lot of financial advisors, as an example, within the industry, something like 300,000-400,000 advisors. A very small subset, maybe 1% to 2% of that in the industry, actually are specialists that deal with these plans day to day. And that's, I think, specialization is really, really important. This isn't about, relationships absolutely matter, but you need to have with your service providers technical competence. I would say one of the other things that has been challenging in the industry is kind of a focus on, I think, profitability. And so generally speaking, what we're seeing, especially on the vendor management side, some of the big, record keepers, as an example, as they're trying to scale, what you're finding is that as fees are getting more competitive, especially on the record keeping side, and you can only kind of access that if you go through a good kind of call it like proposal or RFP process. But also what you're having is the service teams are starting to get overloaded. So one of the big trends I've seen is kind of like service on the record keeping side has really been falling. And so you need somebody who can kind of advocate, that can advocate for you, and that has enough size and scale with different vendors that you get the attention that you need. Because whereas before you might have gotten a response from a record keeper to an issue you had in a day, it might be a week or 2 weeks now, just because as they've grown, their staff is kind of overwhelmed, or staff members are taking on, they might have worked with 25 plans before, now they work with 75, and they can't keep up with it. There's some big trends just in terms of, I would say, that are emerging. They get talked about a lot in the industry side that are emerging. So things like guaranteed income is something that's kind of on it's very nascent still, but you might have been hearing from that. Now offering annuity type investments within retirement plans to give employees some guaranteed income. I would tell you that it's still very early innings on that. I would be very kind of careful. It's something to be aware of. It's something to talk to maybe your advisor about. But just to be aware of that, hasn't been a ton of demand for it yet, but the industry talks about it a lot. So you might have been hearing about those things. And I would say the last one that you hear more and more about is what are called like pooled employer plans. And maybe Dominic, you can talk about this a little bit as well. But there's these kind of pooled employer plans, master trusts that are getting talked about a lot in the industry. A lot of companies, especially small companies, are being called on where it's kind of like a retirement plan in a box, and you can kind of outsource everything. And there are some benefits to it, but what I would tell you is if you're getting called on about a PEP, so a pooled employer plan, there's also some real trade-offs that don't get talked about in the sales pitch that you really want to be aware of. It doesn't mean that you dismiss it out of hand, but usually the potential downsides don't get discussed. And so if you've heard about that, or you've been called on about that, or you're considering that, I would just tell you to go eyes wide open and to make sure that before you move forward in that, it doesn't mean that it's not an opportunity that could benefit you based on your goals as an organization. But there are some really significant trade-offs you make that don't get talked about. And you just want to make sure that when you go in, you're making a decision where you don't have buyer's remorse, because once you get into it, it's kind of like Hotel California. You check in, it's really hard to check out. So I would say those are 4 kind of like emerging things that are happening out in the industry.
Yeah, no, excellent. No, and to piggyback on what you're saying about the pooled employer plan, I mean, a lot of times you're forced to give up flexibility and being able to customize your plan. So there's a singular plan document that governs it. And so the eligibility is the eligibility for all the plans, right? You also sacrifice a lot of control in terms of the investment menu. Moreover, especially for larger size plans, there's not a significant cost savings, and it can actually be much more expensive relative to being able to just going out and offering your own plan. So to your point, Josh, you can definitely go into eyes wide open, and definitely you request some comparisons to and look at offering your own plan versus a PEP side by side. I think that's really the way to go about it.
Can I add one more thing, Dominic?
Yeah.
And I think this is actually important here is, part of the beauty of this webinar, you've got, Dominic on the advisory side with his company. You've got Bender, who's excellent on their side, kind of with what they do on, the benefits and the risk management side. I would say one of the other trends that has affected the industry is there's a lot of private equity and mergers and acquisitions, and you're getting a lot of companies in the professional services space that's kind of getting rolled up. And so a lot of the, I would say, kind of mega vendors that now want to, there's a lot of, I guess, point being, there's a lot of cross-selling happening within the industry amongst one organization that now offers, services across, insurance, benefits, retirement, whatever that might look like. And just because there's one logo on the business card doesn't mean that it's, the best for you. And so you might have found this is all these big organizations are now trying to cross-sell other groups in. And it doesn't mean that can't make sense in certain cases. But I think one of the things to understand, and not many people will tell you this, is that a lot of that is driven by the earnouts from these private equity, these acquisition deals. And so now you've got a retirement firm that is, been acquired by a benefits broker, and they're trying to refer in, the benefits side. And in a lot of cases, it's because they're trying to hit an earnout number. Now, that might not be popular. A lot of people don't like it when I talk about this, but it's something you should realize. And so, don't be surprised if you have my philosophy has always been, find the best of breed. And usually it's not one organization that does everything excellent. It's having separate specialists like you have on this call, with, Bender, with Twin Rivers, is getting the best vendors and putting them on your team. I would just say a trend as the industry is with all of this consolidation is everybody's trying to kind of cross sell, not necessarily because it's best for you as an employer, but it certainly is best for the large companies. So that's just something to be aware of. Like, don't be surprised if you have a advisor and next thing you know, they're wanting to introduce you to their benefits side, or you have a benefits advisor and they want to introduce you to kind of like their retirement plan department. It doesn't mean you dismiss it out of hand, but there is a lot of cross-selling going on in the industry right now. And, in my opinion, you usually don't find big diversified organizations that do everything well. A lot of times having, independent specialists is the best way to get the best experience, both for you and for your employees.
Excellent. No, excellent point. I'm really glad you brought that up. So I do see that we're at time here. So if you didn't have the opportunity to have your question answered, and I do see we have some outstanding questions, definitely reach out to your vendor insurance rep and they will forward it over to us and we will get your questions addressed. But with that, thank you. I'm going to pass it back over to Chad.
Thank you both. Really appreciate you, Josh and Dominic, sharing your expertise with us today. Fantastic. We appreciate you all taking the time out of your busy schedule to join us for this Bender U. As a reminder, the session was recorded and both the recording link and a copy of the slide deck will be sent out to you tomorrow. That's Friday the 21st. And like Dominic said, if you have any questions that come up later, don't hesitate to reach out to us. You'll see on the slide here, our next Bender U, closing the gap, wrap around coverage for California Fair Plan risks. So that's you folks that have property insurance in the California Fair Plan. If you know anybody struggling with property insurance and the California Fair Plan, refer them to this event. We'll see you then. Thank you all very much. Have a wonderful day.